Judge Neal and the Commissioners of the Marshall County, Kentucky Fiscal Court, thank you for inviting Gun Owners of America to speak at the consideration of an ordinance establishing the First Second Amendment sanctuary in the Commonwealth of Kentucky. Make no mistake about it, the enemies of our Constitution are out to take firearms away from law-abiding citizens. Just look what is happening in Virginia. The ink had not even dried on the election results, and the Democrats pre-filed bills to enact draconian gun control legislation. What can freedom-loving, law-abiding citizens do to protect themselves from the anti-gun juggernaut of politicians who hate our constitutional liberties? What can be done when the deck is stacked in at least 2 out of 3 branches of government? And notice I said at least 2 out of 3. In some places, it's all 3. Clearly, someone has to stand in the gap between tyranny and liberty. Someone has to interpose themselves between elected officials who have total disregard for constitutional rights and the citizens they are supposed to represent. And that's what we are seeing happen in the Old Dominion. County supervisors and sheriffs are standing in that gap. They are interposing their authority and are refusing to enforce unconstitutional gun control laws. At last check, and this changes so rapidly, some 85 jurisdictions have passed Second Amendment sanctuary ordinances, or SASOs, we say SASO for short, in Virginia, and more are on the way. Nationally, as of November 18th, 2019, some 240 counties, cities, and towns have passed SASOs in 19 separate states. Illinois, Colorado, New Mexico, and Washington have passed them in a majority of their counties. Without these officials standing in the gap, citizens would be left to themselves to protect their God-given rights. Unfortunately, many of these counties in Virginia and elsewhere have passed meaningless resolutions. While they are certainly well-intentioned, they simply don't have any legal consequences built into them. Instead of resolutions, counties and municipalities should pass sanctuary ordinances that carry the full force of law. To that end, Gun Owners of America has created a model ordinance that has teeth to protect the liberties of citizens. GOA's ordinance prohibits the use of local funds and the enforcement of unconstitutional gun control laws. It contains civil penalties for any violation of the ordinance. Any peace officer can enforce GOA's ordinance. Finally, anyone violating the ordinance can be sued in court with no sovereign immunity protections. The ordinance describes unlawful acts, which include such things as taxation, registration of firearms, accessories, or ammunition, registration of owners, gun bans, gun accessory and ammunition confiscation, and magazine capacity restrictions. I want to congratulate the Marshall County Fiscal Court for considering GOA's ordinance as the model for your Second Amendment sanctuary. I would hope that Marshall County sets the example for what every county in Kentucky should do to protect their citizens from unconstitutional laws, whether in Washington, D.C. or Frankfurt. And by doing this, counties across Kentucky and in other states are standing upon a well-respected legal tradition going back to the time of the Roman Empire, known as the doctrine of the lesser magistrate. A lesser magistrate is an elected official who uses their authority to interpose themselves between the unjust edicts of a superior in order to protect those in his or her jurisdiction. The Roman Emperor Trajan handed a sword to a subordinate and said, "Use this sword against my enemies if I give righteous commands. But if I give unrighteous commands, use it against me." In the 4th century, St. Ambrose blocked the Emperor Theodosius from the church entrance until he repented of the unjust slaughter of political enemies in Thessalonica, and he did. Western Christian civilization furthered this doctrine. In 1215, when the nobles stood on the field of Runnymede and forced the tyrant King John to sign the Magna Carta, they stood between the people and the sovereign's oppressive edicts. They restricted royal power and reinforced that the king had limitations. A little later that century, St. Thomas Aquinas expanded upon the natural law theory of the Roman jurists. The angelic doctor taught us that man-made law could not violate either God's revealed law or the natural law. If it did, the law was no law at all. Moreover, such a law must be disobeyed. Again, we see here a limit placed upon human law and the justification for that disobedience. We see natural law theory being used in the Declaration of Independence, where Jefferson speaks of truths that are self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights. And it is the duty of government to protect and secure those rights, not grant. The government can never grant a right. For if it could grant a right, it could take it away. No, legitimate government exists to protect and secure those rights. And when it doesn't, it ceases to have legitimate authority. All of us are Americans. We believe this, or else our country would not exist. American jurisprudence has always taught and assumed this doctrine of interposition. Black's Law Dictionary defines interposition like this, quote, "The doctrine that a state in this case, in the exercise of its sovereignty, may reject a mandate of the federal government deemed to be unconstitutional or to exceed the powers delegated to the federal government. The concept is based on the 10th Amendment of the Constitution of the United States, reserving to the states powers not delegated to the United States." End quote. Unfortunately, I believe we need to expand Black's definition of interposition to include counties resisting the unlawful mandates of their state legislatures. So Marshall County is standing in this long line of legal reasoning of interposition. By adopting a say-so, you are upholding the supremacy of the constitutions of Kentucky and the United States. Anyone who would seek to take away our God-given rights is violating the supreme law of the land. By passing such an ordinance, you would be upholding the three duties of a lesser magistrate. 1. First duty, opposing any law that goes against the Constitution. 2. Protecting the life, liberty, and property of citizens in your jurisdiction. And 3. By not implementing any laws that violate the Constitution, and if necessary, resisting them. Do not let anyone tell you that this fiscal court would be violating state law. Rather, you are upholding the higher law. If the state legislature or Congress hands you unconstitutional gun control legislation, it is they who are breaking the law. The Constitution is our objective standard of what is acceptable or unacceptable, not the whims of anti-gun politicians. I have not held elected office, but I served my country for 20 years as an officer of the United States. Military personnel and elected officials both take an oath to defend the Constitution of the United States, and the oaths use similar language. Here's what the officer's oath says. I do solemnly swear that I will support and defend the Constitution of the United States against all enemies, foreign and domestic, that I will bear true faith and allegiance to the same, that I take this obligation freely, without any mental reservation or purpose of evasion, and that I will well and faithfully discharge the duties of the office on which I am about to enter. So help me God. Note that our oaths of office, whether military or elected officials, do not involve swearing allegiance to a person, a king, a particular government, a governor, fill in the blank. No, the allegiance is to the Constitution. And when an order is given that is unlawful, it is my duty as an officer to stand in that gap and refuse to obey. Likewise, it is your duty as elected officials to do the same when our essential liberty is being trampled upon, whether in Washington or the state legislature. Notice also the last four words of the oath, "So help me God." Sometimes we gloss over those words and treat them as pro forma, but they are very important. When we say, "So help me God," what are we promising? Are we just entreating God's help for the oath we took? Yes, but it is much more than that. When we say, "So help me God," we are swearing that we will uphold the oath. Swearing. That means we are asking God to judge and condemn us if we violate it. That is why oaths are sworn. We either obey this oath or God judges us. That is very serious. It means that we uphold that oath, even when it places our personal livelihood and position in jeopardy. But sadly, most politicians don't care about that at all. Some skip it altogether. That is another reason why adopting a Second Amendment sanctuary ordinance is so striking. You are showing that you intend to uphold your oath of office regardless of what consequences it will lead to politically or even personally. By choosing to interpose yourselves between liberty and tyranny, between freedom and oppression, you stand in the gap just like our forefathers did in 1776. And standing in the gap not only protects those in your jurisdiction from unjust laws, but it actually spares our country from God's judgment. Ezekiel 22, verses 30 to 31 says this, quote, "I looked for someone among them who would build up the wall and stand before me in the gap on behalf of the land, so I would not have to destroy it, but I found no one. So I will pour out my wrath on them and consume them with my fiery anger, bringing down on their own heads all they have done, declares the sovereign Lord." Will our Heavenly Father find no one in Kentucky to stand in the gap and thus invite God's judgment? Or will Marshall County and other counties in this state interpose themselves to save this Commonwealth? May God give you the courage and conviction to stand in the gap. Thank you very much.
Thank you, Dr. Brennan.